Good morning. This is the second half of chapter 3 for business law, spring 2021. We got through half of the class last time. So I split the chapter in half because it's just a lot of information. So this second half covers trial. So I will share a screen so that you can see this presentation. Okay, so let's see here. Second half of chapter 3. So this is still a sample off of the first set of facts that we talked about this week. So if you remember, those facts of the case are that Tony tied his dog to a post, his body ended up washing ashore. His wife's name is Karen. She went and looked for him. She's the one who found him on the shore. Tony had a business partner. Her name was Beth. She sued for collection of the insurance. So just making sure that we remember that those are the issues for this case, and that we know that the insurance company is claiming that it was a suicide. So they're going to trial right now, trying to figure out, the facts of this case. So regarding juries, I think it's important to know that not all cases are tried in front of a jury. Generally, both parties have the right to a trial, but that doesn't necessarily mean that that you're going to be in front of a trial. So if there's no large amount of money, so generally over $75,000, or if you're not facing any jail time, then generally you don't have to be in front of a jury. So essentially money or personal liberty. But both parties also can waive the right to a jury and only be heard by a judge. So there are a lot of instances where you may just want to be heard by a judge and not a jury. The judge knows far more of the instances of fact and law than a jury. So sometimes people just don't want to take their chances and they'd rather just be heard by the judge. So it's really personal preference. But I think far and wide, most people go with juries, but you don't always have to. The way you say this is wadir. People say it different ways. But this is the process of selecting a jury. So there is a process where both attorneys ask a series of questions. The judge also asks questions of the people in the jury pool. So the court sends a letter to people in your county, and they will ask them to show up at a certain time. Obviously called jury duty. And so they have to show up, 9 o'clock on a Tuesday or, whatever the request is. And if they don't show up, there are serious consequences for it. So you can go to jail. You can also be in Kansas. I know you can pay $100 a day in fines. Sorry, I'm living on chapstick right now. Anyway, and your employer cannot penalize you for being called to jury duty. And it's part of your responsibility as an American citizen. So you can't be penalized for being called to jury. So both jurors, or not both jurors, potential jurors are questioned by both lawyers. So they have two kinds of challenges. They have a challenges for cause, where they're claiming that the juror has some kind of bias, and the judge makes the determination. So the lawyer can say, I think that, this person might be biased for one reason or another. And then the judge decides whether that might or might not be the case. Each side has a very limited amount of preemptory challenges. So that means that a lawyer can get rid of that person for any reason. They don't have to defend it in any way. They can just say, juror number 4 is out. And I don't exactly know. I don't know if that changes for every trial or if every judge decides how many you get. I really am not sure on that one. I'll have to look. But I do know that you have a limited amount. So you can just say, I don't want that person because, that maybe they're a woman or they're older or whatever. There are a lot of reasons that they would just excuse them for no reason at all. So the book introduces another character in our set of facts, and his name's Craig Bergstrom. Throughout what we've gone over so far, I haven't seen the real relevance to this, but I put it in just so we kind of know that there's another player. But Craig Bergstrom was an old friend of Tony's, and he is there in court, because anybody can watch court, with the exception of like, juvenile cases, things like that. Courts are public. So, you could go this afternoon and watch a court hearing. As a matter of fact, and maybe I'll give you guys a link to this stuff. You can watch court hearings on YouTube right now in McPherson County, which is interesting to say the least. But Craig is his friend, and he thinks that he knows why Tony is dead. He thinks that he killed himself, but he was never questioned by anyone. And he knows that he might have some relevant testimony, but he was never asked by anyone about any information he had or anything. So he is sitting in the courtroom listening to all of the testimony going on during the trial. So when a trial starts, you have both sides give opening statements. So it's essentially each attorney is saying exactly what they're summarizing about the proof that they're going to show. The plaintiff always goes first because the person needs the ability to defend themselves to go last. So they tell the jury, here's what I intend to prove over the course of the trial, and here's how I think you should decide the case. The plaintiff has to prove, or they have to prove their case. So they have what's called the burden of proof. They have to convince the jury that their version of facts is correct. And they must do that by a standard called the preponderance of the evidence. That means that the plaintiff's version of what happened is slightly more likely or a little bit more believable than the defendant's version. And if that's the case, then the plaintiff has shown the preponderance of the evidence and they win a trial. So Janet, in our set of facts, is going to go first. She is the person, they're suing the insurance company, her with Beth. So Janet has to prove several things to make her case work. She has to prove that Tony is dead, which should be pretty simple. But she's going to have to show in court that he is in fact deceased. So she's going to show up in court with her evidence of, here is the death certificate stating that Tony died, etc. The second thing that she has to prove in court is that Tony's death was an accident. This is clearly a little bit more difficult, but she's going to do this by calling witnesses to testify. And this, when she calls witnesses to ask them questions, that's called direct examination. So Janet's going to call Beth to the stand and ask her questions that prove her case to the jury. And then Rich, who is the defense attorney, he's the attorney for the insurance company. When it's his turn to come up and ask questions of Beth, so Janet has called Beth to the stand to prove her case. When Janet is done asking Beth questions, Rich gets up to ask questions, and that's called cross-examination. The rules of evidence are gigantic and complicated, to say the least. The book covers that in like a paragraph. So essentially, lawyers can't just ask anything they want. It's not the Wild West in the courtroom. There are laws of evidence that guide lawyers about what they can ask. It allows for what documents can be produced, that sort of thing. So people can only testify to what they personally saw or heard or read or whatever. They can't testify to what they believe someone else may have done or seen. They can also only testify to things that are relevant. So for example, Karen, who is Tony's wife, she testifies on the stand that the dog is in Newfoundland. And so the other attorney objects and he says it's completely irrelevant that the dog is in Newfoundland. And then the other attorney argues, well, it's important to know that the dog is in Newfoundland because every time Tony would go swim in the ocean, the dog would go out to rescue him because their breeds are made to rescue people out of the ocean. And so then it becomes relevant that the kind of dog is the reason that Tony probably tied the dog to a fence. So then maybe Karen spends hours on the stand answering questions by the defense about her private life with Tony. Some of those things might be relevant, some of them may not be. But you have to understand each side is trying to prove, one side's trying to prove that it was a suicide and one side was trying to prove that everything was fine and he just accidentally drowned. So their personal life together, the kind of dog it is, those things are probably fairly relevant to this case. Now, if we call a marine biologist that testified that people could get caught in currents out there, that's fairly relevant testimony if your argument that is that he accidentally drowned. Now, the question is, are these things relevant? They're all arguable. So either side can object to the evidence brought into court, and then they argue them either in front of the judge on the sidebar or via motions. So after all of the evidence has been given, the parties can go for a motion for directed verdict. So the defense can say, we move for directed verdict because the plaintiff hasn't proven anything in their case. So a directed verdict, you can only have that if any reasonable person wouldn't be able to disagree that they didn't prove their case. So there's essentially no reason to go forward because let's say, for example, and this would be a long shot, and I don't even know if it would really work, but an example would be if Janet never introduced evidence that Tony is in fact dead. If she never introduced evidence of an autopsy or a death certificate, things like that, then she hasn't proven a major element of the case, which is Tony is in fact deceased. Maybe he's still missing. She hasn't proven that. So a motion for directed verdict might be granted in that case. So then once Janet is done presenting her case at trial, it's Rich's turn to put on his case for the insurance company. He has an entire different group of witnesses, and Janet gets up to cross-examine those people. So Rich is going to show testimony and bring in evidence for things that are going to help the insurance company, and he is not going to bring in witnesses that he thinks may not help his case. So remember Craig, who's sitting in the courtroom. It's Tony and Craig, they talked about all their problems, affairs, things like that. He was not asked to be a witness by Rich. And I don't think the book mentions whether or not Rich ever talked to Craig, but the insurance company didn't want to have him in this case for one reason or the other. After both sides have gone and each side has given their all of their evidence relevant to the case, then both lawyers sum up all of the facts and all of the things that they have tried to prove during the trial. And those are called closing arguments. So they give you the set of facts based on what you heard and saw at trial. And then they explain to the jury how they want to interpret them. I ask that you find that Tony in fact killed himself because of the following evidence that we've given, and that Beth deserves $0. Or vice versa. So Beth's argument would be the dog was tied up. We proved the dog was tied up so that Tony could swim out without the dog. He could get in the water. And then the marine biologist testified that the current quite possibly was very heavy that night. And so he likely drowned, right? That might be a sample of Beth's closing argument. So Rich's closing argument is going to say, we presented evidence today that Tony was very depressed. He tied up the dog so the dog wouldn't come and save him because the dog was in Newfoundland. He knew the dog would come out and try to save him, and he drowned on purpose and committed suicide. So those are examples of things that they might bring up in their closing arguments. So after closing arguments are completed, the judge is going to instruct the jury as to what their job is today. So their job is to evaluate the case based on everything that they heard at trial. So all of the evidence brought in by both sides. So that's all the testimony, all of the pieces of paper, all of the, the items maybe that they had to see during trial. They are required to rely on their common sense, which is frightening sometimes in jury trials. The judge explains the law to the jurors and then explains the burden of proof, which it could be different for different things, but essentially he says, which one do you find a little bit more believable? And whoever you find more believable, the money goes to that person. So if Janet proved that Tony is dead, Beth is entitled to $1 million. If Janet proved that Tony had an accident, then she is entitled to $2 million. So the judge will explain those things to the jury after they've heard all of the evidence. So then if Rich proves this is more of what the judge is telling the jury. If Rich has proved to you that Tony committed suicide, then you have to come back after deliberations and tell us that Beth deserves $0. If the jury takes all of that stuff and they're unable to decide between the facts, then there is the presumption that his death was accidental. So they take all of that information and they go deliberate together in a room in private. And when they come back, they deliver, the judge delivers a verdict based on the jury's decision. So some juries will deliberate for an hour, 30 minutes, whatever. And, some juries have deliberated for 2 weeks or a month. This jury, in our sample case, took a day and a half. So just before the jury returned with its verdict, Rich decides to make another offer to settle the case. Now think about why he may want to do that. They may have sat there during the course of the trial and just maybe got an uneasy feeling about some of the jurors, or they could tell on some of their faces that they weren't buying some of the argument, or they heard during the course of trial some of the witnesses seem more believable than others. There's 150,000 reasons that somebody might offer something while the jury's out. But he offers $350,000 to settle the case to Janet. So think about $350,000 on a $2 million claim. Is it something that you would consider taking for your client? And then ask yourself, if he offered 1.5, would you take it? So, in this instance, if it were me at this point, knowing what I know going forward, if he offered 350, I would likely reject that. Obviously I have to ask your client, but I'm saying, okay, if I were Beth personally, I might reject 350. Now, if he sat there and offered me 1.5 million, me as the attorney for Beth, I would say you need to take that right now, because based on what happens after this, winning $2 million doesn't mean what you think it means. So there are also motions after the verdict. So Rich is immediately going to ask the judge to overturn the jury's verdict. That's called a J&OV. And then Rich also argues that the judge's instructions were wrong and that he misled the jury. And that happens quite a bit, where the judge might give the wrong kinds of instructions to people. But the judge did deny all of his motions. So, and I think for some reason, I don't recall saying this, but in this matter, the jury came back and found that Tony's death was accidental. So the jury found for Beth. So they came back with a $2 million verdict. Now I don't want people to think, because this never happens. It's not like at the end of trial, somebody sits down and writes a check to the other person. That's not how any of this works. Because 2 days later, after the trial, Rich files an appeal. But the same day he files the appeal, he calls Janet and said, hey, the appeal's filed. Here's a copy of that. I'm going to offer you $425,000 today if you want to settle the case. So Janet and Beth, they're discussing it. It's possible that the Court of Appeals will order a new trial, that it'll take an enormous amount of time to even get to court, and they'll acquire more expenses, because oral arguments at this point for the appeals court are scheduled for 8 months from the day that Rich offered the $425,000. So then at what point do you take the $425,000? It's really just it's a chess game from here on out. So when Rich is in appeals, the court can say, yes, the trial court was right. They can change the decision a little bit, which generally doesn't really happen, or they can reverse and remand the decision, or they can simply just say, no, the jury was wrong, the judge was wrong, and here's the actual decision. But what do you think the Court of Appeals will do based on Beth's case? It seems pretty cut and dry. They decided that there was an accident. They had a few things to prove. It seems like Beth was able to prove that based on what happened. So they should likely affirm the trial court's decision. There doesn't seem to be any potential error, that I noticed in the book anyway. So that makes a huge difference about what kind of settlement offers you're going to take from there on out. So then Rich, with that set of knowledge, comes back with another settlement. So based on that, the court can take months to make a decision. So you have 8 months until oral arguments. They've probably taken a year to get to trial anyway. So at this point, Tony's been dead almost 2 years. Rich offers $900,000 to walk away today. Janet comes back and says, you know what, we'll settle right now for 1.2. They have conversations back and forth, which is noted in your book, but Janet ends up taking the 900. But why would she settle if she knows that she might win the appeal? There's lots of reasons, because Rich can appeal to another court. It can take, Beth is also sitting there with no money, incurring expenses, and likely needs this money to continue the business that, Tony's been deceased. And so she hasn't been able to do a number of things because of lack of money. So that's likely why she took the $900,000. Now, you can't avoid all of this stuff, right? You don't have to go to trial. You don't have to do any of this. And a large number of major corporations are doing alternative dispute resolution. So by far, most cases in the United States are settled through negotiation, by far. And this is neither, sometimes it's not done between lawyers, courts, or any of that. But often a mediation is just a quick and easy way to get a dispute settled. So a mediator will guide both parties into a settlement that works for both of them. It's often voluntary. I know, I almost said especially McPherson. I think by far most courts will order mediation before they'll take something into court. I think family law has to start out this way. I could be making that up, but I think a lot of that, like divorce, child support, all of that stuff, they want people to mediate that stuff. They want the mom and dad, to agree to visitation, to child support, to all that stuff. You don't want a court who doesn't understand your family or your lives or your children to decide all of that stuff. So the judge will often order mediation first. And if you're unable to come to a decision, then the court will step in and make decisions for your family. But that can also be done in civil cases also. That's just an example. So the job of the mediator is just really to listen to both sides, have them sort out some of the serious issues, and then leave some other stuff to the side that maybe isn't that big of a deal. They have to be able to listen to both sides. People are often really angry. Generally in these disputes, people aren't happy to be in court. They're not happy to get sued. The mediator themselves, they can be judges. Sometimes they are, but they don't have to be. They don't even have to be lawyers. They can just be somebody who's good at getting people to agree to things. There are entire companies that are just mediation companies where you can hire a mediator out of there. So they don't have to be a judge. There are a lot of benefits to mediation. Everything's confidential. So if you drag somebody into court, everything's public record. Any person can go sit in court and listen to it. Anybody can pull the pleadings. All of it, anything's public record. So you have a little bit more freedom to speak and share and talk about what it is that you want in a negotiated settlement, in a mediation. The parties can control when they meet, where at, that sort of thing, rather than waiting for trial dates or being pushed out 5 months or continuances, things like that. And generally, both parties can win something in mediation, whereas in trial, there's one clear winner. It's not like the judge gives a little bit to each side and lets things be even, where mediation absolutely can be. So there's a different kind of resolution called an arbitration. So it's the same concept as mediation, but the third party can impose damages. So a mediation is never going to result in anything. You can come to a resolution together. You can sign an agreement and say, this is what we agree to, and you can move forward. In arbitration, there's a decision. So, this person wins and the other party needs to pay $500,000, whatever it is. This is what those shows like Judge Judy are. So those people these are actual cases, and those people will agree to arbitration. So Judge Judy is acting as an arbitrator, and her decision is a final decision on the matter. What she does is, and I've heard this, that they have people from the show look at some of the local court filings to see if they can find some interesting set of facts that might be fun for TV. And then they'll offer those people to come into court, and I believe they cover their court costs to come to the show. So Judge Judy's making a final decision. She's actually affecting the outcome of that case, but it is technically arbitration because that's a TV show with made up stuff. Arbitration also prevents class actions. So if you have a credit card, there's often an arbitration agreement in it. So a lot of large corporations are requiring customers, employees, all of that stuff to commit to arbitration before anything even happens. So what they're saying is, okay, we agree that you're a Capital One client or customer. If you want to continue to use the card services, you agree to arbitration in the event of any dispute. And so if you continue to use the card, you're just automatically agreeing to that stuff. That means that you can't go with a group of people and sue Capital One for, outrageous fees or collections issues, whatever it is. So nothing's, for their sake, nothing's publicly disclosed. You can't ask for discovery back and forth, so they don't have to expose a lot of documents. And you can't get together with, 1,000 other people and do a class action against a major corporation. So that is the rest of, the rest of that chapter. I will post, we have chapter 3 assignments. I moved out to the end of the week since everything's kind of wonky. I'll be honest, I don't even know if I have internet right now, and hopefully this is just recording. So we'll meet on Thursday for the second sections, so the section 2, and we'll go over chapter 4. But I moved out the assignment for chapter 3 to the end of this week so that you guys have some extra time. So as you're going through this and you have more questions, let me know, and I will help you as much as I can. So you guys have a good week, and I'll see you in a few days.